those watching on the live stream, I should say it's really nice and cool in here.
I'm grateful for that.
Oh. Yes.
I have a number of things to go back on. The first one was a question from my Lord Justice Arnold. The answer is yes. The question I was to take instructions on, make sure I understood correctly. In our case, the clients would not have the clients would not have got anything had they accepted the Sheikh's capped offer.
The clients would not have
got any financial reward had they accepted the Sheikh's capped offer. And that was the question that was put to me. What actually was the position with recovery, having regard to the Sheikh's capped offer and the costs outstanding?
Well, so let me repeat the question that I asked, because I'm not sure what you've just said is an answer to it. So the question I asked was, is it accepted by Candey that Candey would have had no claim against the Boshes if the Boshes had accepted the Sheikh Mohammed offer that had been negotiated by Mr. Candey?
Yes. By that, if my Lord is talking about the costs claim, that's exactly right.
All right.
That, I should add, is the capped offer. That's where my reference was to the capped offer. The next point, just to mention, was we brought to court, sort of for completeness, the Immerman case that was referred to us, referred to the parties yesterday.
Yes.
And so far as that goes, it approves of paragraphs 75 and then again at 142 the passages from the Istiel case where for reasons of confidentiality Justice Collins refused the relief claim sought by the claimant. And it's exactly right that what had happened was that otherwise privileged material had been passed over to the defendant by, quote, Istiel friend who was a witness. And that's what the suit was about.
I mean, it's usually taken as the leading case on material improperly obtained. In the context of confidentiality.
Inman is yes, absolutely.
Yeah.
Because, of course, in that case, what had happened was there had been wholesale hacking into the husband's computers to get records, which were then passed over to the wife, which she sought to use into the...
Precisely so, and that's why the issue was confidentiality, not privilege.
Yeah, my lord, I agree. I accept that. But equally, I remain with my previous submission. Now, on that submission, I should have showed the court, which I intended to and didn't, the passage from Phipson at divider 26 in file 3, page 873. I showed the court one passage, 878, at 874 in the...
Sorry, can you just wait a moment while we get there? Can you enlighten me? Is this the current edition? It is the current edition. Yes.
I'm sure it is, my lord. Unfortunately, the way it's copied, we haven't got the front piece for the.
Right. And sorry, which part were you looking at?
I wanted to show the court page 874, and this was in response to the discussion about Paragon and Freshfields and Justice Tugendhat's decision in Hagendorf.
Yeah, and so that makes the point that we were discussing earlier. In Paragon, the Court of Appeal could have, but did not, put the decision on the basis that there was no claim.
My lord, exactly.
So I appreciate that the logic of your submission receives support from the learned editor, but as a matter of authority against you, isn't it? As he points out.
Well, it is decided on a different basis. So the question is whether it precludes the basis on which I advance the case. And Lord, I submit that it doesn't, and I don't want to repeat myself going back over old ground. I thought it right, though, to draw to the court's attention.
Well, indeed so. I completely agree with that. But again, if one's going to look at Phillips more widely, I mean, the other aspect one has to take into account is the two sets of proceedings question, because that's the rationale for the Goldman and Hespen case that you rely upon, as is discussed elsewhere in Phillips, because it's analysed as a limited waiver for the purposes of the taxation proceedings and not any waiver.
Absolutely, but of course, again, in contrast with
there's other cases on the same theme, such as Bournes and Rakin.
But that particular decision, as it happens, is on the question of inter partes taxation, as opposed to what was actually referred to by the judge in Hackendorf, which is solicitor and own client taxation. And it's actually worth, again, my learned junior reminded me, at Divider 27, there's a note from the Bar Council, current note of guidance and confidentiality. And what the Bar Council was trying to grapple with is the possibility of a barrister having difficulty recovering fees. Now, once upon a time, this probably didn't matter, but now fees are contractual and so forth. We find that the Bar Council is trying to work out, having regard to Lillicap and Nadler, Paragon and Hackendorf, whether or not a barrister can actually pursue the client for fees and how the barrister will go about it. And one will see in paragraph 13 what the Bar Council's belief is.
Page number.
Sorry, I beg my Lord's pardon. It's 800. The note starts at page 884. And the relevant passages are sidelined at page 885, page 886, and then materially paragraph 13 at page 887. And it is obviously a problem when one has a question, can I get my fees from the client? They're now due to me. And one has to, if it went grounding the matter on waiver or implied waiver, one has to postulate that the refusal to pay the fees is itself a waiver of confidentiality and privilege, which is a very surprising position.
It'll always depend on the individual circumstances. I mean, if a barrister's claiming for fees and the client is saying he didn't do any work for me, and the information showing the work done is a claim for privilege, well, one can see that would be waiver, but potentially.
Well, except that the barrister has to get there. It has to, and the problem is that the
it's
barrister
$1 million miles from a £3 million fraud claim.
My Lord, yes.
I'm anxious about the time.
Yeah, absolutely. I'm sorry, I won't go back.
Your learned junior wants to sweep us.
Sorry, could I just ask one question before we leave this? Because if we look at paragraphs 8, 9 and 10, it's all about implied waiver. So they start in paragraph 8 with Lillicrap, Arnold and Paragon. Then they go through Hackendorf in 9, and the conclusion that you're relying on in 10 is based on implied waiver. It's not based on there being no privilege in the first place.
Well, except they're trying to fathom what it seemed to me, when one looks at, again, in paragraph 13, very difficult to postulate that there's an implied waiver and a refusal to pay fee. I mean, but anyway, I will pass on to the next point, which was Ablyazov and ground and the fraud ground, the iniquity ground. Now, in our skeleton, we've referred to Barclays Bank and Eustace and Brent London Borough against Kane, as well as Ablyazov. This is paragraphs 26 and 33. The first two cases, I won't trouble the court with. I can tell the court that the first one's at page 24, divider 3, and the second one is at divider 12, page 244.
So Barclays Bank is at divider
3, page 24.
Yeah.
And the second one is Divider 12, page 244, both within Volume 1. And within the Barclays case, it's page 35B to C and 36G. And within the second case, one really needs to see paragraphs 2, 27, 28, and 32, paragraph pages 248 to 250. Now, what the point about that is that those cases are clear that the exception, if you like to call it that, is brought into play not merely where there is fraud, but where also there is iniquity in a wider sense. So it can come into play where there's iniquity. Then there's the Ablyazov case, which I will take the court to, which is at Divider 11 in the same bundle, page 181. As one can see from the first 3 lines of the head note, the case was the Claimant Bank, victim of fraud, trying to get hold of documents which prima facie be subject to professional privilege, being documents in the hands of solicitors consulted by the defendant. And you can see again that point being made at page 182 between letters C to D. And then we get the head notes description of the conclusions. Between letters F to G, one sees the proposition: in the ordinary run of criminal cases, a solicitor will be acting in the ordinary course of professional engagement, even where the defendant put forward what the jury found to be a bogus defence. But where in civil proceedings there was a deception of the solicitors in order to use them as an instrument to perpetrate a substantial fraud on the other party in the court, that could well be indicative of a lack of confidentiality, which is an essential prerequisite for the attachment of legal professional privilege. The deception of the solicitors, and therefore the abuse of the normal solicitor-client relationship, would often be the hallmark of iniquity which negated the privilege, and that's consistent with human rights. Now, it's important that the context of this was a third-party disclosure case. So that one, of course, one's into the area in which a third party can recover communication between client and solicitor. At page 201, there's Justice Popplewell, as he was, leads off with a discussion of the law, Cox and Railton, obviously, and Kuwait, on criminal purpose and privilege. And then at 69, he deals with the point that there are 2 types of privilege: legal advice privilege and litigation privilege. And the point is made at paragraph 71, by reference to actually criminal cases, that privilege is not prevented from attaching merely because the solicitor is engaged to conduct litigation by putting forward an account of events which the client knows to be untrue, which therefore involves a deliberate strategy to mislead the other party in the court and to commit perjury, as is clear from the examples given.
Given the time, the summary is at 93, isn't it? That's where he draws the strands together.
Well, yes, but actually also, my lord, the court will need to keep in mind paragraph 76, 75, 76, ordinary run of cases, because the question that's before the court in this present case is whether the present would qualify as an ordinary run of cases. And the learned judge below held that it did. And Mr. Justice Popplewell identifies 3 considerations. First, legal professional privilege attaches to communication between solicitor and client, which are confidential. The quality of confidence is a prerequisite to the privilege because it's the protection of such confidence which forms the bedrock of the rationale for privilege as essential to the administration of justice. I mean, that's my proposition about the distinction between the 2 things.
Well, the judge set all this out in her judgment.
Oh, I'm sorry, my lord.
I mean, we're not arguing from first principles. The judge set out 76 and 93 and then purported to apply those principles to the facts of the case.
Right. So, we say that this case is not the ordinary run of cases, because what's happened here is that on our case, the solicitor has been the person deceived, the victim of the fraud, and it's the solicitor who wishes to rely on the material in question to pursue the client. Now, that's hardly the ordinary run of cases in which a client tells a story to the lawyers, which is presented in court and turns out to be untrue. This is where the solicitor has been induced to act, we say, fraudulently. That was our case. So it's not an ordinary run of cases example. And when one sees the judge's observation of paragraph 52, for example, the learned deputy judge is trying to determine distinguish what we would say is this case, and suggest that it ought to be an ordinary run of the mill case. She's identified express contractual terms, paragraph 51. In paragraph 52, the dishonest client is not protected in this sort of case. Deceitful statements, the sort raised by the claimant, will, if material to the outcome, usually be disclosed outside the cover of privilege. For example, in open court in the client's pleading. They may also be part of the retainer, not privilege. Now, in our case, yes, we would say that the privilege, the statements made in the defences and counterclaims contain false representations. One can see how the pleadings changed in the course of the proceedings, of the settlement proceedings.
But you haven't been prevented from relying on those documents.
No, but that doesn't say anything about the communication between the client and the solicitor, which is other prima facie confidential. It doesn't allow one to go behind and say, by the way, the reason that this was put before the client and signed was because the client told us X, Y, or Z. So yes, that material is available, but without the communication that's otherwise private, it's not going to go anywhere. So that was my submission in answer to that particular paragraph, my lord. I would suggest the other ground, paragraph 51, it really leads to the conclusion that in a CFA case, the solicitor needs to include two things. One, a warranty by the client that what is being told and will be told is all truthful, and two, an express waiver of privilege. But that's going to be an interesting landscape change if that's how, in the future, CFAs have to be advised, or have to be taken on if there's going to be an avoidance of the sort of problem that's arisen in the present case. And this one is an extreme case, it's fraud. What if it was just simply to try and recover the costs? Recover the stipulated fee. Here, the defendants, the Boshehs, have waived privilege on the settlement discussion. That's expressly stated. But logically, what that means is that the court can entertain, because of that waiver, but only because of that waiver, the claim on the cost term. And then the other argument that we submitted in our skeleton was the cherry-picking argument, that if it's waived, if there is waiver of the material which allows us to pursue the cost claim, naturally we would say that it must allow us to pursue claims in the proceedings about the wider matter, namely the merits of the action.
Well, that again is an enormously wide submission. I mean, courts up and down the country every day, people waive privilege in relation to a particular document or particular strand of document for a particular reason.
Absolutely.
To say that then must give rise to, as it were, some sort of coach and horses argument would really, I mean, there must be some authority if that is right.
Well, again, we've had included in the bundle of Phillips extract, which has the two parts to it. It's the cherry picking on a document, the Atlantic, I think, case, which half of the document is put in evidence, and that would normally mean that the whole.
But it's not suggested in relation to the settlement the communications as to the settlement that we've only got half the material.
No.
We've got all of the material, just shambolically arranged. But we've got all the material, so I mean, it's going it a bit to say, well, as a result of the waiver of that, there must be waiver of categories A, B, C, D, and E as well.
It was the proposition that you have collateral waivers to a wider class of material, and we would say the wider class of material goes to the merits of the underlying dispute. But my Lord, I don't want to take up much time. That was the cherry picking argument that is in our skeleton argument, and there's the authority on the in the back of Phillipson. What we also say, and so, as to ground 5, which feeds into this particular ground 5 is whether or not we could properly plead the allegations of deception in the two points that were put forward in the proposed amended particulars of claim, namely as regards the Yahoo account and the RBS account. And we accept that if we've failed on ground 1, we have to fail necessarily on ground 5.
Yeah.
We would also suggest that if we succeed on ground 1, then we ought to succeed on ground 5 to be allowed to plead the allegations of deception, specific deception. Then finally, ground 2. There are two aspects. This is as I mentioned. One is the material that was received after the termination of the retainer, namely an envelope with some bank statements for the RBS deposit account.
Yes, and on that, would you accept that on the authority of Imam, your clients committed a breach of confidence by reading those documents when they read them?
I wouldn't accept, at any rate, by the reading, because they need to know what they were. They'd arrived.
No. Imam says if the documents are confidential, it's a breach of confidence to read them.
Well, in order to determine that question, something needs to be done with the documents. That's to say,
you send them back. That's what you do. So what's the answer to Imam?
The answer to Imam is well, my Lord, if my Lord is of the view that opening the letter to determine what's inside it and whether it needs to be dealt with as a breach, then I would suggest it wasn't. The bit that's
you can open the envelope, see what they are. You see that they're the bank statements, and at that point, you know that they're confidential. You know the retainer's over, and therefore your duty is to send them back.
All I was cavilling at was the proposition concerning the opening of the letter and the identification of them. The use of them, I would accept, my Lord.
So you would certainly accept that analysing the information contained in the bank
the
statements
only justification for it would be by reference to the iniquity exception. And as to that, my Lord, there was a basis for supposing that that exception should apply in the form of the disclosure statement that had turned out to be, we would say, false.
I'm not sure I quite
But the point at the moment with those documents is that The question is whether they may at a future time be used, not whether we are going to use them tomorrow. It's that if the proceedings go on, if supposing we succeed on ground one and the proceedings go forward, then should they become relevant, can they be the subject of disclosure and use? That's the only question that is now alive on that class of documents.
The judge found at paragraph 62 that the claimant failed to provide a good excuse for its decision to inspect and retain the RBS bank statements that it received after it terminated its retainer of the defendants. There's no lawful basis for retaining and reviewing.
There's no appeal against that point.
I was going to say, and there's no appeal. So the answer to my Lord's question must be correct. There was a breach of confidence. That's what the judge has found.
I accept there's no appeal on that, and the judge has found it. I accept that. All that is alive at the moment is the conclusion that they may never be used again in the future. By that I mean that if the circumstance were to rise when they're relevant in proceedings, they can't be called for to be produced. That's the whole scope of that particular application.
I hesitate to interrupt, my lords, but if I could draw your attention to paragraph 64. I don't believe that the judge did say that they could never be used and would never be dismissed.
Right. Well, at the moment, the form of order, it's somewhat like the second point, the Al-Masri witness statement. The form of the order at the moment appears to go further than that proposition. And as to the...
Wasn't the order drawn up by consent?
I can't tell, my lord, how the matter went back.
You have a huge number of issues for the deputy judge to deal with. There are hundreds of you, there's one of her. Conventionally, parties agree an order for the judge then to sign off to reflect. It's not a consent order, because it's an order that reflects the judge's judgment. I'm a bit anxious about parsing the judge's order. I mean, 64 refuses permission.
Okay. At
this stage.
If that's all it is, then I don't need to argue further on this point. Nor indeed, I suspect, do I need to make any further argument on Mrs. Al-Masri's statement, as to which there's an unconditional permission to use in the future. The form of order is let's say, unhappy, but that's beside the point.
Well, subject to anything that Ms. Eilert says about the Miss Al-Masri statement, for my own part, that seems to me to be a complete non-point, in the sense that she gave permission, but it was prospective. The argument is, well, it wasn't retrospective, but it looks as if that could be obtained. So it doesn't seem to me to be at the forefront.
No, it's absolutely
numerous
not.
Interesting issues that the parties have raised.
It's absolutely not, my lord. Yeah. But so far as Immerman is concerned, we don't need to really go there. No, I was just going to draw attention to a passage on Immerman, but I won't trouble the court.
In Immerman?
In Immerman, but it's already been referred to and discussed.
Is that, well, you can give us the reference. Is that in...
It was paragraph 142, the first sentence. That was all. It's a point I already made, but as I also agreed, there's not been a challenge to the judge's finding on the point. So.
Tab 29 in volume 4.
Thank you.
Unless there's anything further.
Just so that I understand the shape of it, you dealt with ground 5 flowing out of ground 1 and ground 7 too?
I did also pass very swiftly over ground 7. That's the claim based in conspiracy and
Yeah.
inducing breach. And my point about that is that that's dead if we can't succeed on ground one. If we can succeed on ground one, then in principle we ought to be able to proceed on ground 7.
Okay.
But
So
the question is that's a point of pleading, nothing
Yeah.
else.
So the short point for the structure is that ground 7, like ground 5, also follows if we were against you on ground 1.
On ground 1, exactly.
Yeah, fine. Understand. Richard, any other? Well, if that's it, Mr. Bumpers, thank you very much. Yes, Simon.
My learned friend said to me at the end of his submissions that it would be an interesting landscape change if the solicitor had to include into his conditional fee agreement an express warranty that the client should tell the truth and an express waiver of privilege. But what my learned friend and the appellant are seeking to do is in effect to include both of those terms, but as implied terms or as functions of the law of implied waiver. And in my submission, it would indeed be an interesting landscape change, and it is not one that this court should support, or indeed one that is supported by the authority. My lords, obviously this is an appeal not of a trial, but of various summary judgment to strike out and applications to amend. And in such applications, the court's role is not to conduct a mini trial. So, notwithstanding that the appellant's claims are strongly disputed by the respondents, some of my submissions will proceed obviously on the basis that the appellant's factual assertions are correct. And as your lordships will be aware, that is not to be taken as any indication that they are in fact correct.
Yeah.
I was proposing to take the grounds of appeal in order, unless you'd like me to jiggle things around a bit.
Fine, I take whatever order you like. We obviously give no guarantee that we would follow either your order or indeed Mr. Bumpers' order, but by all means, at least for the note, it has a certain cohesion. Yeah.
So starting therefore with privilege, and in my submission, if one follows the appellant's position through to its logical conclusion, it boils down to this: that where a solicitor accepts a case on a conditional fee basis, and the client makes a statement in relation to its defence beforehand, then if the client wins, the solicitor gets its hourly rate fees and uplift, subject to any cap, as expected. But if the client is found to be dishonest in relation to that statement, or, as here, the solicitor later decides that they were dishonest, then privilege evaporates, such that the solicitor is free to make public prima facie privileged information in proceedings against its former client. And, secondly, the solicitor is entitled to its fees and uplift, apparently ignoring any cap in the agreement, as damages for fraud. I would be forgiven for wondering, in my submission, particularly in fraud claims, where the honesty of the client is very much an issue, where the contingent element would fit in, and why a client's entitlement to privilege should depend on whether they win or lose at trial. In my submission, there are also further difficulties. One of your lordships indicated that there might be a estoppel in relation to whether or not the client was in fact dishonest in the particular statement, but since the solicitor would not have been party to the proceedings, arguably at least you'd have to rerun the entire proceedings in order to find out whether the client was dishonest, between the solicitor and the client, with the corresponding risk of inconsistent judgments. And that's Roger's system. Such an approach would, in my submission, have a significant adverse effect on access to and the administration of justice, and as one would expect, it is not, in my submission, supported by authority. Now, the starting point in relation to privilege is, I think my learned friend and I both agreed on this, is in Regina and Derby Magistrates Court. And this is in Volume 1, Tab 4. This is a case case where a man had been arrested for the murder of a girl. He'd admitted to the murder, and then he had later retracted that confession, and he said that the page reference is 40. He'd retracted the confession and said that his stepfather had killed her. He was acquitted. Later, the stepfather was on trial for murder, and the man gave evidence for the prosecution. And the defence sought production of the man's instructions to his solicitors prior to the retraction of the confession. If you could turn to page 60.
The well-known passage is at 60D, isn't it?
The well-known passage is at 60D. And at the end of that passage, it is a fundamental condition. Privilege is a fundamental condition on which the administration of justice as a whole rests. And if one just goes to the paragraph at B, further up the page, that's a quote from Phillips and Cousins, about the middle of that paragraph. It is only if the client feels safe in making a clean breast of his troubles to his advisers that litigation and the business of the law can be carried on satisfactorily. And indeed, over the page at 61, the House of Lords was asked whether there should be rare exceptions where the rule of privilege should yield to other considerations of even greater importance. And just below B, Lord Taylor said no. He said, but the drawback to that approach is that once any exception to the general rule is allowed, the client's confidence is necessarily lost. The solicitor, instead of being able to tell his client that anything which the client might say would never in any circumstances be revealed without his consent, would have to qualify his assurance. He would have to tell the court that his confidence might be broken if in some future case the court were to hold that he no longer had any recognisable interest in asserting his privilege. And one can see at once that the purpose of the privilege would therefore be undermined.
Yeah.
So that, my lords, is the starting point of privilege. And that is the purpose of privilege in the context in which these arguments come up. Turning then to the appellant's arguments, first the iniquity exception.
Well, you take them in whatever order you want, but of course the more fundamental argument that's been advanced by Mr. Bompus is that there's no privilege in the first place, because this is a communication between a solicitor and a client. As between each other, there's no confidence, and all the documents are in the possession of the solicitor, so there's no question of compulsory disclosure. And so if that's right, he doesn't need the iniquity exception.
My lord, yes. My lord,
So I mean, by all means, tackle them the other way around if that suits you better. But logically, the no privilege argument comes first.
So no privilege to start off with. My lord, yes. I just reiterate that this point was not, in fact, in the appellant's skeleton argument, and it's being raised today. My lords, in my submission, your lordships have already identified many of the reasons why this just doesn't make sense. And it is contrary to existing authority. But just going back then for a moment to Derby Magistrates, page 61, at the end of that paragraph I read in relation to C. So the drawback to the approach is that once any exception to the general rule is allowed, the client's confidence is necessarily lost. So the solicitor would have to tell the client that his confidence might be broken if the solicitor at some future date decided to bring proceedings against the client. And indeed, one can see at once that the purpose of the privilege would therefore be undermined. Because my learned friend's submission in this regard, that there is no privilege because privilege is to do with forcible disclosure of documents, or resisting the forcible disclosure of documents, is that sorry, lost my thread there. The effect is that not only, as it was put by the learned judge in Hackendorf, as it was put obiter by the learned judge, and wrongly we say, in Hackendorf, would a solicitor be able to rely on privileged information in an action properly brought by the solicitor? But the solicitor would be able to use privileged information in actions improperly brought. In my submission, the protection of privilege is the protection of documents from disclosure to other persons. And in Goldman and Hesper, there is a comment, and this is behind tab 1. And if you turn to page 9, around C, normally where privilege exists, it applies to disclosure not only to the opposing party, but also to the court. So the rule, which was one brought in by legislation, clearly makes inroads into that general protection.
Yeah, so let me see if I can tease that submission out a little bit. So as I understand it, what you're saying in reliance upon that passage, putting it in my own words, is that true it is that there's no confidentiality as between client and solicitor, but that does not mean that there's no confidentiality at all. On the contrary, both client and solicitor owe the other an obligation not to disclose to third parties. And that the third parties, including the court.
My lord, I'm not sure that the client necessarily owes a duty not to disclose to third parties.
Well,
It's the client's privilege,
true. It's the client's privilege he can waive, but the solicitor owes the client. Yeah.
Yes, my lord. So disclosure to the court, particularly in circumstances where disclosure to the court is disclosure to the world at large. And my lord, the other point is that this is.
And then so then one gets into the conundrum of how is it that the court is able to determine an issue as to privilege in the way that I was discussing with Mr. Bompers. Now, one answer to that might be that it has to be safe insofar as it is strictly necessary for the court to discharge its functions. So if in this scenario where there's a dispute as to privilege, someone's got to decide, and therefore you could say it's strictly necessary. But I don't know if there's any other rationale that you would argue for.
My lords, yes, I would distinguish between the cases like this case where it is a dispute and the cases where the court is exercising its supervisory judgment or where it is determining a matter which, as you say, the only way that it is possible to determine it is for the court to look at it. And there is a distinction between those two roles of the court.
So that's finance.
So that's finance. And in my submission in relation to finance, it's relevant that certainly if the trustee were bringing an action for claimant directions, then there are provisions for confidentiality, so the hearing would now at least be listed in the first instance in private. And the claim form could be in general terms. That comes with the caveat that I think in finance, certainly the Court of Appeal hearing was not in camera, but we don't know about the first instance. But in my submission, there is a distinction between the court in its supervisory role, where a trustee or an officer of the court comes and says, please help, and the situation where a solicitor brings a contested dispute against a former client, and in so doing, puts that privileged information before the world. Or potentially puts that privileged information before the world. And the other point, in response to my learned friend's submission about confidence, is that which, my lords, you've already identified, that it is in fact contradictory to previous authority. Paragon Finance proceeds on the basis that there is privilege and that there is an implied waiver in certain circumstances. As did the other case, I believe you quoted from.
Lily Crappell Nordland.
In that respect. And similarly, the Bar Council's guidance makes it clear that extreme care should be taken when taking action for payment of fees. It's not when you have a claim for fees you can use whatever you want. It's be very careful, and if the only reason, and this is at paragraph 13 of volume 4, sorry, behind volume 3, behind 7, on page 887. It's very clear that the guidance is to be very careful and only weigh that which is necessary. And disclosure may not be relevant if the only anticipated response is that the defendant cannot afford to pay your fees, as opposed to, for instance, an allegation about the quality of your work. It's linking it to that idea that it is for the client to bring the relationship into the public sphere, and it is only once the client has brought that relationship into the public sphere that you have the implied waiver. My lords, if one teases out my learned friend's point a little further, it is hard to see how it doesn't undermine privilege completely. Because the solicitor could disclose the documents. Once those documents were disclosed, generally they wouldn't be subject necessarily to privilege. Inadvertent disclosure, then you get into questions of confidence. So that it's entirely unclear. It's just entirely unclear how it fits with the concept of privilege at all.
Are the documents in the solicitor's hands privileged because he holds them as the client's agent?
But on my learned friend's submission, if he chose to disclose them in any proceedings against the client, then effectively they'd be up for grabs.
Well, playing the privilege does remain. For example, if the solicitor mistakenly supplies them to a third party, they will still remain privileged. It's not as though the privilege is in some way being destroyed because the solicitor has them.
Yeah, I can see that the privilege in that respect hasn't been destroyed. So as long as the solicitor keeps them and maintains them, but the purpose for which privilege, the purpose underlying privilege, and the purpose for which privilege is in existence is destroyed because the solicitor can always use those documents against the client, even if it appears that is using them in public proceedings and disclosing them to the court. And once you accept that, which in my solution the authority does not, but once you do accept that, then you get back to that point in Dark Magistrates Court. If you've undermined the confidence of the client, you've made that exception, you've
So your bottom line submission is the purpose of privilege would be destroyed if the solicitor could use them, but you accept, I think, that that's subject to the iniquity exception and Ambrose of.
Yes, in my submission, the iniquity exception is not an exception properly so called.
Because privilege doesn't attach at all. But yeah, okay, fine, I understand that. But if you're right about that, you say you then have to look at it by reference to the Ambrose of test.
I'm saying that you have to look at it in relation to the
Or implied waiver.
or So then turning to Ablyazov, which is in volume 1, line tab 11. At page 181 again. And then the analysis of the law starts at page 201. Paragraph 69 reiterates the principle that where legal privilege exists, it's inviolate. Over the page, paragraph 71, such privilege is not prevented from attaching merely because the solicitor is engaged to conduct litigation by putting forward an account of events which the client knows to be untrue, and which therefore involves a deliberate strategy to mislead the other party in court and perjury. And then further down that page, around F, this is a quote from the Snaresbrook case, via the Kuwait Airways case. Obviously, not infrequently, persons allege that accidents have happened in ways other than the ways in which they have in fact happened, or that they were on the correct side of the road when driving, while actually they were on the wrong side of the road, and matters of that sort. Again, litigants in civil litigation may not be believed when their cases come to trial, but that is not to say that the statements they have made to their solicitors pending the trial, much less the applications which they made if they applied for legal aid, are not subject to legal privilege. And then skipping ahead to paragraph 90. And this is in the Kuwait Airways case. The application
Give me the page number.
Page 200. The application of this exception to cases where the privilege claimed as one of litigation privilege is likely to be rare. It will, of course, not be enough that a solicitor has simply been a conduit of untruthful evidence. And then over the page on page 209, that's paragraph 93.
Yeah.
So the touchstone is whether the communication is made for the purposes of the conduct of actual or contemplated litigation, which is advice or conduct in which the solicitor is acting in the ordinary course of the professional engagement of the solicitor. A bit further on, in cases where a lawyer is engaged to put forward a false case supported by false evidence, it will be a question of fact and degree whether it involves an abuse of the ordinary professional engagement of a solicitor in the circumstances in question. The learned judge at first instance was clear. As a matter of fact and degree, this does not fall within the iniquity exception. And in the respondent's submission, she was obviously correct. The communications on which the appellant seeks to rely, the instructions and statements made for the purposes of defending proceedings brought by Mr. Sheikh Mohammed against Mr. Bosheh and his son, Mr. Salvati. In other words, they were communications within the ordinary professional engagement of a solicitor. This is some way, some considerable way, from the facts in Ablyazov, where there was a deliberate strategy of concealment with advice being taken with a view to furthering that strategy. In this case, the statements were made for the purpose of the litigation. It's within three final points on iniquity. First, as your lordships will have noticed, the respondent's position is that the appellant's proposed express representation gave us no real prospect of success in any event, such that there's no prima facie fraud on which to base the iniquity exception.
So just expand on that. Where does that point go?
It goes because the appellant says that there is something more than just a false statement here, because there was a fraud on the solicitor.
Yeah.
And in my submission, first, there was no prima facie case of fraud because of the express representation. And secondly, that if one analyses their position, in fact, their case of fraud is simply based on the alleged falsity of the alleged misrepresentation. And we can see that from paragraph 27 of their skeleton argument, which is behind tab 4 on page 48. Paragraph 27, it starts on the page before and carries on, and towards the end of that paragraph, the law is clear that if there is a knowingly false representation intended to be relied upon, which causes inducement, in respect of which there is a strong presumption not displaced by suspicion, that is the end of the matter. So if you boil their case right down, what they're saying is, there was a false case put forward, we've lost out. Therefore, there's fraud. So there isn't anything in my submission to take it beyond. Secondly, the appellant suggested at the hearing, and this is reported in paragraph 95 of the judgment, which is at tab 7, page
113. This is halfway down the paragraph. In oral submissions, the claimant wisely suggested that it was no longer alleging, and then later on that Solomon made fraudulent misrepresentations. Now the privilege. So what's the relevance of that?
So the privilege was good. If Solomon, if it is no longer alleged that Solomon and Bosheh made fraudulent representations, then his privilege, and it was a joint privilege, his privilege exists. So it would follow the privilege continues. And in Abdiazov, I think the bank accepted this point rather than there being any argument, but it's on page 221, paragraph 134. It is accepted on behalf of the bank that there may be documents held by the solicitors in which there exists joint privilege between Mr. Abdiazov and natural persons independent of Mr. Abdiazov. Such privilege must be protected because it is unaffected by Mr. Abdiazov's iniquity.
Yep.
The third point in relation to iniquity, the respondents, and this links as well to the submissions that have been made today in relation to good faith. The cases that's been presented today in relation to an implied term of good faith suggested that there were two things to consider. One was settlement and one was the honesty of the statements.
Yeah.
In my submission, and I'll take you to the pleadings in this regard, it's not pleaded, and it's not part of the proposed amended particulars of claim, that there was a breach of any implied duty of good faith by reason of being But if it is, and if the appellant's submission is that the three cases, Barclays and Eustace, Nationwide Building Society and London Borough of Brent, would then allow a breach of that implied term of good faith to trigger the iniquity exception. In my submission, that's wrong. And if I could just take you to the cases briefly in that regard. Barclays and Eustace is behind tab 3. And it's page 24.
Tab 3, page
24.
Yep.
And this was in relation to legal advice that was given in relation to a transaction, which it was later alleged was a transaction with a creditor. So 2 points to note here. First, it's concerned with legal advice privilege.
Does that matter? Is there a relevant distinction between legal advice privilege and litigation privilege in this context?
In my submission, there isn't how one approaches it. First, because it was made clear that, and this is on page 39, that even though disclosure in this case was permitted of documents in relation to the carrying out of the transaction at the time, so the legal advice obtained at the time, those documents concerned with the litigation of subsequent proceedings were privileged, and privilege continued over those. Now, it's said that this shows that this is indicative of a relaxation, or that all you need is iniquity.
All you need is
iniquity rather than fraud, or sometimes it's said something less than fraud. But if you could turn to page 38 and about E. Lord Justice Sheeman noted that the evidence in the present case reveals a strong prima facie case of what the side note to section 423 refers to as transactions defrauding creditors. So we are in fraud territory. Nationwide Building Societies at tab 6.
just so I understand where this is going. I understand your point that you say there's no allegation of a breach of good faith in relation to inaccurate statements, but you're now going on to say that these cases don't trigger the inequity exception in relation to privilege in any event.
And in particular in relation to that. So it's not pleaded. So the good faith allegation in relation to honesty is not pleaded. And it would need to rely upon, presumably, privileged information. And in my submission, it doesn't trigger the iniquity exception. In my submission, nothing triggers it, but particularly an alleged breach of bad faith wouldn't trigger. Sorry, an alleged breach of an implied term of good faith would not trigger the iniquity exception, because what the iniquity exception is concerned with is fraud. So Nationwide Building Society, tab 6. It's again a case on legal advice privilege, and this is in respect to advice obtained at the time of the impugned transaction in relation to mortgages. So it seems to be relied upon by my learned friend as suggesting that something less than fraud suffices for the iniquity exception. But if you turn to page 94, which is the application of the the application by the judge of the law of the facts. And at subparagraph 4 there, so in the judge's view, in the TC case, there was a sufficient foundation of fact to support the iniquity charge, and there the pleadings included a point of claim that there was fraudulent misrepresentation. But in BR, further down, there was not a sufficient case made out that there was any fraudulent purpose. And the points of claim made no allegation of fraud in the earlier statement of claim in the action. It's alleged in paragraph 8 that these matters cast doubt upon the value of the property and or the honesty of the borrower and were indications of a possible mortgage fraud, but that was as high as the matter went. And the points of claim made no allegation of dishonesty, bad faith, or other impropriety.
How does this tie in with the concession that, for the purposes of these applications only, as you've made plain, fraud is in play?
For the purposes of these applications, the concession was that the alleged misrepresentations were false, rather than that there was any fraud more generally in play.
Okay.
False and knowingly false.
I think just false.
That's not enough for anything.
For the purpose of the privilege of the iniquity exception arguments only, I think it follows that if they were false, given that they were made as statements of the defence, I think it follows that the concession is that they were knowingly false. But this is...
But that's deceit.
No, deceit. The tort of deceit has many claims, has many elements. There must be representation, it must be false, it must be knowingly false, there must be inducement, there must be loss.
But aren't those all things that are alleged against you?
Those are all things that are alleged against me. In my submission, just in relation to the concession that was made in the skeleton argument, for the purposes only of dealing with the iniquity exception. The concession was that it was appropriate and convenient to deal with the iniquity exception arguments on the basis that the representations were false. But I specifically state that it is not conceded that there is any prima facie claim of fraud by the solicitor, not least because in my submission there is no real prospect of success because there's no real prospect of establishing inducement. I may be complicating the matter because I've been complicated in a way by my learned friend's switch in relation to...
I understand that. I understand that. I mean, this is what you described as your third point. The first point of which, if right, ends it, because you say the good faith arises in relation to settlement, not inaccurate statements.
Yes.
Yeah.
My lord, so those are my submissions on iniquity, which, to sum up, is a matter of fact degree. The judge correctly identified that as a matter of fact degree, this is within the ordinary course of litigation. Turning then to Hackendorf, and this is behind tab 8 in volume 1, page 116.
Yeah.
In my submission, the judge was correct to distinguish it and find that the comments on privilege were obiter on the basis that the wife had not identified any privileged, facing privileged material upon which the wife, the solicitor had relied. So my learned friend relies on 3 arguments here. The first is Finance and Myro, then there's that's possibly only 2 arguments. First is Finance and Myro, and then there's the solicitor is able to use it against a client in proceedings properly so brought. So Finers and Miro, as we've already discussed, in Finers the solicitor was approaching the court in its capacity as trustee for guidance. This is a very different case. In the incident case, the solicitor is bringing proceedings against a former client for damages. In relation to paragraph 70, which I think is also linked to paragraph 71. So this is where the judge said, sorry, not paragraph 70, paragraph 72, neither party has put before me any authority on waiver of privilege in relation to actions brought by a solicitor against a former client. That such actions are open to a solicitor is not in doubt.
Sorry, your which authority are you in?
Still
Hackendorf. Okay, sorry. Yep, come
on. Over the page 73, there is of course no breach of confidence or breach of privilege in a solicitor reminding her client of matters communicated to her by her court. The potential of breach of confidence arises if at all when it's disclosure to a third party. Where proceedings aren't in public, the disclosure complained of must be limited to disclosure to the court. And then at 74, sorry, not 74. 75 is where the judge finds the first point, so the first answer. The wife's not specified the precise information. Then at 78 is Finers and Miro, and then it's 80. If I were wrong about this, it seems to me that justice requires that I should not discharge the order on that account. A solicitor is entitled in suing for her fees to the same rights as other litigants, in particular access to justice, equality of arms and a fair hearing. And over the page, if I were wrong about that, and if I had to resolve the question of principle, would decide that in favour of the solicitor, and says that the position, as it seems to him, is that there may well be a situation analogous to that in Paragon and Finance. In other words, he's looking at an implied waiver. And in my submission, if one looks at Paragon and Finance and Waiver in any detail, one can see that this doesn't amount, in my submission, to an implied waiver. In Paragon and Finance, the rationale for implied waiver was set out by Lord Bingham of Cornhill, and the relevant passage is at page 72. It's behind tab 5 in volume 1. And at page 72, starting just below D. When a client sues a solicitor who has formally acted for him, complaining that the solicitor has acted negligently, he invites the court to adjudicate on questions directly arising from the confidential relationship which formerly subsisted between them. Since court proceedings are public and the client brings that formerly confidential relationship into the public domain, he thereby waives any right to claim the protection of legal professional privilege in relation to any communication between them so far as necessary for the just determination of his claim, or putting the same proposition in different terms, he releases the solicitor to that extent from the obligation of confidence by which he was formally bound. This is an implication of law, the rationale of which is plain. A party cannot deliberately subject a relationship to public scrutiny and at the same time seek to preserve its confidentiality. He cannot pick and choose. In my submission, that is an entirely different situation from where a solicitor has brought the proceedings into the public realm. And in Hackendorf, the judge seems to have been influenced to a large extent by what one might term issues of fairness or issues of public policy. But the problem with that, as we know from Derby Magistrates Court, where the person seeking privilege, the documents that were said to be privileged was on trial for murder, is that once privilege exists, it's inviolate. Fairness doesn't come into it. And I won't necessarily take your lordships to it, but there's a quote of Lord Lloyd of Berwick on page 62 in Derby Magistrates Court, where he recognises that there may be cases where the principal will work hardship on a third party seeking to assert his innocence, but in the overall interests of the administration of justice, it is better that the principle should be preserved intact. My lord, if there can be waiver, implied waiver, by a solicitor bringing an action against a client, then it would seem to follow that there would be implied waiver in circumstances where a person gave evidence for the prosecution, where they previously been admitted to murder and then retracted the confession, or indeed where a client put their solicitor in the position where they were defending a wasted cost. If one accepts an implied waiver of the notion in manner tentatively put forward in happy law, then one is effectively allowing in the balancing exercise, the prohibited balancing exercise found back law. And there is the one final point. If the solicitor cannot establish the conditions necessary to bring into play the iniquity exception, why can they then rely on lesser conduct to bring into play an implied waiver? A final point that was put in my learned friend's skeleton argument, and not, I think, pursued in any detail in submissions, is that the appellant has suggested that the judge below should have held the hearing in private and permitted the solicitor to use the privileged information. This is both an unattractive and misconceived argument. It is unattractive because Mr. Candey, in his evidence at first instance, specifically stated that the hearing should be in public. And this is at tab 11 of the supplementary bundle at page 159, at paragraph 60. And that the hearing below, the appellant took a neutral position on the question. And it's misconceived because, of course, the solicitor cannot unilaterally impose upon the court an obligation to hear the matter in private simply by relying on privileged materials and bringing a claim against its former client. The question whether a hearing should be in private is one for the court, taking into account a number of matters, not only privileged information but also the principles of open justice and transparency. So whenever a solicitor brings a claim against the client, there is always the risk that the solicitor will be thereby bringing those proceedings into the public sphere.
And the related point, the protection of that material, you deal with that in paragraph 7 of your skeleton. You say that we should deal with it on the same basis as the judge did. Any reference to a document was not to be treated as the document having been deployed or used in open court.
Yes, my lord, and in fact there is an order to that effect until further order.
Yeah.
Court hearing.
So if we...
And yes, I would indeed ask that.
Fine.
my lords, unless you have any further questions on privilege, I would propose moving on to ground 2.
Yeah, I think you can probably take ground 2 quite quickly, given how Mr. Bumpus put his submissions.
My lord, yes.
Well, sorry, I hesitate to rise. I think that looking at my skeleton, I've made a mistake here, in that although, as I see it, ground 2 is prospective only, a point arose out of the discussion I had with Lord Justice Arnold on the question of whether or not there was a breach of duty by Candey in looking at the skeleton, looking at the documents, and then using them. That's actually touched on in our skeleton argument, that past matter, and strictly I think is a ground of appeal, although I didn't pursue it. But it's a paragraph 44.
Yes.
And I don't think I should abandon that.
No, but we looked at paragraph 62 of the judgment.
Yes, it doesn't make, this point doesn't make any difference. It's only that I fear that I have conceded something which I shouldn't have done by reference to our skeleton. As I see it, this question is entirely prospective, not past, and therefore the point that's developed in the skeleton doesn't arise. But I wouldn't want to let it pass that I've accepted I've abandoned what was said about Immerman in that paragraph in our skeleton argument.
You say it's prospective.
I say that the ground of appeal is only concerned with the future, and therefore the ground of appeal is very slight. However, because the judge was dealing with it, obviously at the time that. Correct.
I mean, she wasn't dealing with retrospective, prospective.
No, but the point it fed into.
The judge was dealing with it as a matter of common sense.
Absolutely, but it also fed into the question of a freezing order then being sought and no longer being sought. So the learned judge made findings which are dealt with in our skeleton argument, but which, in my submission, don't actually arise or matter for the purposes of the present appeal. But I wouldn't wish it to be said that I abandoned the point.
To be sure, and you're quite right to be careful about abandoning points that you're not instructed to abandon. I take that point. But can I just probe a little further your suggestion that one can, as it were, divorce the future from the past? Because is it not the case that key to the reasoning in Immerman is the proposition that if you breach confidence by reading the confidential documents and extracting information from them, then the starting point is that you should not be allowed to use that information in the future.
Well,
there is, of course, room for an exception to that. But the starting point is that the past breach of confidence should lead to you be restrained from using the information in the future.
Well, I accept that, but it's not the proposition is that the order is subject to the possibility of exception in the future, should the occasion arise, which it may never.
Yeah.
That was the point there.
All right.
Just give us a moment. Well, in the light of that, Miss Ida, unless there's something that you have a burning desire to say in relation to ground 2, it doesn't seem to us that we need to hear from you.
My lord.
I mean, it's said that the points in the skeleton all go to what the judge did, but Mr. Bumpus accepts now that the position is that there may be an exception in the future, and they may want to rely on that, but that situation hasn't arisen and may never arise, and they're not seeking now to attack the judge's findings in relation to the position as in relation to confidentiality at the time she dealt with them, including the various criticisms that she makes of their conduct.
My lord, I think on that basis, I have nothing to say. nothing to say on that matter, no. In relation to...
I mean, speaking entirely for myself, and so that it doesn't come as a surprise to anybody, I thought that confidentiality was a weak ground of appeal in this case, in relation to the criticism of what the judge did, because it seemed to me that what the judge did was entirely unexceptionable. Now, rather, I've revealed my hand, everybody else is keeping theirs very close to their chest, but that's it, that's what I think. So we may not have asked for your submissions anyway, but as I say, that's the position. So,
but to be crystal clear, so far as the future is concerned, you're not here to argue that they can never, ever, in any circumstances, apply to court for permission to use that information.
The respondent's position is that the judge precludes them from using the documents unless and until those documents are disclosed in the normal course of disclosure.
To be sure, but in theory, let's leave aside the question of how practically realistic this is. In theory, there could be an application for disclosure and there could be an order made if sufficient justification is made.
In theory, yes. The judge's
Exactly.
judgment reflects that.
Yeah.
My lords, in relation to Ms. Al-Masri's statement, just to make sure that we're on the same page.
oh yeah.
The respondent's position is that consent was given during the course of the hearing. So the respondent's position is that the order reflects and the appellant can use that statement going forward. But in the respondent's submission, what the appellant can't do is rely on previous use of that statement.
But the order enables them again to apply if they so wish.
If they sought to take her statement and use it going forwards, in my submission, the order...
But even as regards the past,
But
the
even as
order
regards
doesn't
the-
shut them out from an application for retrospective permission.
My Lord, there may then be a confusion here because going forward, we don't need any court permission on this one. Because
Exactly.
it has got consent.
Yeah, that's common ground.
Absolutely.
The only question is the past.
Yes, ma'am, but they couldn't rely on the previous use in the statement of Mr. Candey or applications.
Yeah.
Well, again, just in case that it doesn't come as a surprise to anybody to learn that I did not regard this point as at the forefront of this appeal. Of course, when the Supreme Court say that we were completely wrong about the Al-Masri statement, I'll obviously have to revise that. But until then, that's my view. So do we come to good faith?
We do come to good faith, my lord.
And I should also, just for clarity, be sure that, do you accept that grounds 5 and 7 follow from ground 1?
My lord, I accept and indeed submit that if the appeal on ground 1 fails, then the appeal on grounds 5 and 7 also fail.
Right, that's all right.
In my submission, the converse is not true.
I follow that. Yep, okay. So good faith.
Yes, my lord. Just before moving to the substance of my submissions on here, I think it's worth just having a quick look at the judgment of Mrs. Justice Ambrose below, which is behind that set. Page 110.
Yeah.
And at paragraph 81, the claimant, so the appellant alleged that the retainer was subject to a number of implied terms. First was that the Boshehs would act or their instructions would be motivated by their best interests alone. Then that they would at all times act in good faith towards the appellant. And then the amended case contained an allegation of an implied term that Mr. Bosheh would cooperate with, give a full and accurate account of the case too, and not deliberately mislead the claimant. The learned judge found that there was no real prospect of success in relation to the first and the last of those implied terms, and that has not been appealed.
So when you say the first and the last, so that we're clear, first is
The first is that the Boshehs would act on their instructions would be motivated by their best interests alone.
yeah,
And the last is that Mr. Bosheh would cooperate with, give a full and accurate account of the case to, and not deliberately mislead the claimant.
yep,
My learned friend submitted that the alleged implied term good faith had two constituent parts, one relevant to the settlement of the proceedings and the other an obligation to give accurate information about matters in question, which is very similar to the implied term that was found to have no real prospect of success below. Turning to the particulars of claim.
and just for the note, those two implied terms that she rejected, 85 is the first one, is it? Paragraph 85.
Yeah, paragraph 85 is the first stage of her rejection.
Yeah. And the full and accurate bit.
I think the full and accurate bit is that I think is in 83 because it starts off with the obligation to cooperate. So she says at the second sentence, the implied term to cooperate was not necessarily in light of existing law reflecting Mackey and Dick. Alleged implied term obliging Mr. Bosheh.
Yes, I see. Okay.
And then at 88, she sums the whole format up. So then turning to the pleadings, behind tab 10. So paragraph 4 sets out various representations, including that the Boshehs would at all times act in good faith towards the claimant. And paragraph 5 says that the retainer contained implied terms to the same effect. Then paragraph 12 over the page on page 130 says further alternatively the Bosheh's conduct set out above was a repudiatory breach of the implied terms. The conduct set out above is at paragraphs 9 and 10. And it said that the claimant sought and obtained an offer from Sheikh Mohammed, sets out the offer. And then at 10, that the Boshehs instructed the claimant to reject that offer and make a counter-offer rejecting any payment to the Boshehs, and it's averred that the defendant's counter-offer was substantially less advantageous than Sheikh Mohammed's offer, but more advantageous to the second defendant. And in the amended particulars of claim, it's clarified that page at page 150.
Yeah.
At the end of paragraph 9, and this is the case as it's now put by the appellant, that it was a proposed term of the Sheikh Mohammed offer that the monies were only to be paid towards the Bosheh's cost liability.
Yeah, well, that's apparent from the emails.
In my submission, it's not apparent from the emails. Once one turns to them in detail, and I will take you to those.
Okay.
So in relation to this concept of an obligation to give accurate information, it isn't pleaded in my submission, and the judge found that there was no implied term in terms to cooperate with give a full and accurate account of the case to and not deliberately mislead the appellant, and that's not appealed. And just to respond to a point that was made in my learned friend submissions earlier, it is correct that Mr. Bosheh had the counterclaim against Sheikh Mohammed, but Mr. Solomon Bosheh did not.
Yep.
So looking at whether one implies a term of good faith, the respondents share your lordship's concern with the alleged implied duty of good faith, and in the respondent's submission there's neither a real prospect of successfully implying a term nor of successfully establishing a breach. And if I could take you to Bates, which is what the respondent relies upon, which is behind tab 28, page 1065.
I couldn't hear the page, I'm sorry.
1065.
Yep.
Mr. Justice Fraser sets out the basic characteristics that he considered relevant to whether the contract is relational or not. The first one is that there must be no specific express terms in the contract that prevent a duty of good faith being applied into the contract. In this case, there was, of course, the costs term, which might be thought to be relevant to the issues that appear to be complained about, namely that both cases accepted the settlement but did not provide for payment to the appellant's solicitor. In my submission, the parties had already considered this point and they'd addressed it. A settlement should, I forget the terms exactly, but the cost term was designed to say that there was an obligation to seek, not to obtain, but to seek costs. And in relation to the second point, the contract will be a long-term one, as your lordship identified, with a contract of litigation retainer. It might be for a very short term, the parties might settle, or it might be for a longer term, but it is not a long-term, a necessarily long-term contract, and indeed, the conditional fee agreement was entered into in January 2021 and the proceedings settled in June 2021. The parties must intend that their respective roles be performed with integrity and with fidelity to their bargain. Certainly, it was intended that the solicitor should act with integrity. The solicitor was under duties to do so. Quite what it said that Bosheh should have done is not clear. Certainly, they should have paid the appellant's fees if the obligation arose under the contract, but it didn't. The appellant's skeleton merely says that it is reasonable to expect that the defendants will be honest and act with integrity. But my lords, in my submission, reasonableness is not the test. Certainly, if one looks at the standard test for introducing implied terms, it's not that the term is reasonable, but the term is necessary. And the term is necessary for business coherence. The court's role is not to simply rewrite a contract. The parties will be committed to collaborating with one another in the performance of the contract. There was no such commitment here, and at the hearing below, Mrs. Justice Ambrose found that the appellant had no real prospect of success in relation to an implied term of cooperation. The appellant could have sought to include an express term of cooperation or assistance, but it didn't. What there is in a solicitor's retainer to the effect that the solicitor can terminate a retainer if it's unable to obtain instructions. And that's implied. And in my submission, that's a clear indication that there's no commitment on a client's behalf to collaborate. The spirits and objectives of the venture may not be capable of being expressed exhaustively in a written contractual. On the contrary, the objective is that the solicitor represent the client and act in the client's best interests in the litigation. The parties had agreed to a written contract, and indeed they had expressed their minds to certain matters which might arise. And then we have, they will each repose trust and confidence in one another, but of a different kind to that involved in fiduciary relationships. Well, clearly the trust here was not of a different kind to that involved in fiduciary relationships, because there was a fiduciary relationship. And it's worth turning briefly to the Hume case, which is behind volume 2, tab 16. Page 415.
Yeah.
Towards the bottom of that page. Such relational contracts involve trust and confidence, but of a different kind from that involved in fiduciary relationships. The trust is not in the loyal subordination by one party of its own interests to those of another. It is trust that the other party will act with integrity and in a spirit of cooperation. And in my submission, in a solicitor's retainer, the trust is the loyal subordination of the solicitor's interests to those of its client. And then the contract in question will involve a high degree of communication, cooperation, and predictable performance based on mutual trust and expectations of loyalty. Again, there's expectations of loyalty from the solicitor to the client, fiduciary duties, but there's no predictable performance. And whilst there might be a high degree of communication, that's not a contractual requirement, and it wasn't implied in this term. And again, the solicitor is entitled to terminate the retainer if it's unable to obtain the instructions. There may be a degree of significant investment by one party or both. Certainly, the solicitor here did the work, and the Boshehs incurred hefty contingent obligations, but there was no venture per se, and most contracts involve significant financial or other commitment. And exclusivity of the relationship may also be present. Here, the clients were, of course, free to terminate the retainer and instruct other solicitors, and the retainer itself provided that if they did that, and they went on to win, then the client would pay double the payment. So that contingency has been provided. Other factors that went into Mr. Justice Fraser's conclusion that there were relational contracts in that case, the investment of the SPNs involved buying or leasing premises, major significant personal commitment, and the post office knew the size of the investment and the source of funds, and the role of an SPN providing personal service entitled that SPN to benefits that have similar characteristics to an employment contract, such as employment, holiday substitution, allowance. And this is at the bottom of the page in Bates, paragraph 728. My Lords, the suggestion by the appellant is that because this is a developing area of law, the court, judge below, shouldn't be satisfied that there's no real prospect of success. In my submission, that's tantamount to saying that as long as one includes an implied term of good faith somewhere in one's pleadings, one gets a free pass to trial. If one looks at the position in my submission, whether one looks at it in Bates, or I can take on also to the standard test for the implication of terms, which is summarised in the Waiver Plus and Appellant, which is behind tab 14 in volume 2. There is no real prospect of success, successfully establishing that there is any implied term of And in relation to the standard tests, I would, in fact, I will just take the lordships to volume 2, tab 14. Starts at page 310 and at page 321.
Tab 14.
Tab 14, page 321. There's a summary of the law on implication of terms. At 33, little 3, 4 conditions, reasonable and equitable, either necessary to give business efficacy to the contract or so obvious it goes without saying, although in practice probably both will be present, must be capable of clear expression and must not contradict any express terms of the contract. 4, the test is not one of absolute necessity, but a more helpful way of putting this requirement may be the term can only be implied if, without the term, the contract would lack commercial or practical coherence. And over the page on 322, a term should not be implied into a detailed commercial contract merely because it appears fair or merely because the court considers that the parties would have agreed it if it had been suggested to them. Those are necessary but not sufficient grounds for including a term. And in my submission, in any event, if it had been suggested to Mr. Bosheh that he would have had to subsume his interests or his non-economic interests to those of Candey's, that would definitely not have been obvious. May well be doubtful whether the parties have failed to make provision by oversight or whether it's a deliberate omission. And in the latter case, implication is impermissible because it's contrary to the intention of the parties. And finally, it is not enough to show that the parties had foreseen, that had the parties foreseen the eventuality which in fact occurred, they would have wished to make provision for it, unless it can also be shown that there was only one contractual solution, or that one of several contractual solutions would have been preferred. In other words, it is not sufficient if it is necessary to imply some term, it must be necessary to imply the term which is contended for. And in my submission, that is particularly relevant given the multiplicity of the implied terms that were put forward originally. So again, in my submission, this may be a developing area of law, but whichever way you cut it, there is no real prospect of successfully implying
the law on the implication of terms isn't developing. I mean, around the edges maybe, but the core principles are here.
The core principles are there.
Yep.
My lords, then we look at what's alleged to be the breach. And for this, I'm afraid we do have to go to the settlement.
Yes.
So if we start in the supplementary bundle defined to have applied on page 81.
Miss Eilert, just so that I'm clear, for the purpose of the notes, this is your point, paragraph 4 of your respondent's notice, that the appellant has no real prospect of successfully establishing that effectively there was a breach, or that Bosheh's counteroffer was substantially less advantageous than Sheikh Mohammed's offer.
Yes.
Yeah. Okay. So we're in
the supplementary bundle.
Yeah.
At page 81 behind tab 5.
Yeah.
So if we start about 2/3 of the way down, there's been some previous communications, and someone states, please, it's just on the halfway, please let us know what the exact plan regarding negotiations is. We think that if by the end of tomorrow there is no progress, we would like to approach with a drop hands offer, as we are worried that if something will go wrong, BM, which I understand to be Baker McKenzie, will ask us to pay their fees, which will be over 1.5 million. Many thanks. Going up the page, Mr. Candey responds, understood, and then he goes on to say, there's been a suggestion that a payment is made to you in full and frank. The proceedings against Ambrose and others continue. Neither you nor Bosheh give evidence. Please.
So wait, you're still on page 85?
81, sorry.
Oh, 81. Yeah.
Please can you confirm that this is in principle acceptable? And I should attempt to get as much as possible. I assume that it must be acceptable. Please do not discuss this with Amjad, as he obviously would want to have the claims settled. And Solomon says, please give me some guidance as to the level of offer we're expecting. Share with us any email exchange, or please give a call. And then Mr. Candey responds, I assume that even were they to agree to £50,000, this would be acceptable. I propose that we make an offer in the terms below in the sum of 1.2 million, but that you agree that I should use my best skills to get whatever we can above £50,000. And Solomon comes back at the top of the page that you mean 500,000? And then if we go to page 80, and at the bottom of that, Mr. Candey confirms 50,000. Solomon, obviously I will try and get as much as we can. Solomon comes back with, I don't really understand where this £50,000 comes from. I've not mentioned this figure. If we drop hands, we do this for the benefit of myself and my dad and all the others, and we do it in coordination. If they want to drop our case only, then I would expect a proper settlement as they will gain, not us. My preferred option is a reasonable payment and a drop hands on all fronts. I understand that settlement will be the subject of 28% for your fees from any claims covered on both myself and Dad. Our clear instructions is to drop hands in coordination with all defendants. However, if you think you can get us money, then go for it. So clearly there, he's asking Mr. Candey to negotiate the money. Somewhat surprisingly, Mr. Candey comes back that he's very concerned with the email and sets out the terms that he says are agreed. He states, there's nothing in the agreement about a drop hands for Amjad, although I did confirm that a drop hands for you would mean that you would not have to pay us. And Solomon responds at the top of the page, and then that big email is a replication of the terms of the CFA that we saw earlier.
And the advice given, which was the point I raised with you before in the second paragraph, is if we receive £1 million, it'll be paid to us in cost. That is only right and fair.
So that's what is said there, but if we just look at the next email up, so Solomon responds, I don't think I was understood correctly, not instructing you also to settle Amjad as he's running an independent case. And then at the last sentence, the agreement of fees speaks for itself, and you are aware of our interpretation. We can discuss later, but let us focus on favourable settlement by close of business today. And the respondent's position, and I don't want to go too much into the cost term, but the respondent's position is that if one looks at the terms of the agreement, it was a capped CFA. So where money came in for costs, and that went to the solicitor, where money came in generally, then that was subject to a 28% cap that went to the solicitor, and the rest went to the Boshes.
Okay.
So there's a difference of opinion in construction. And then there follows a series of emails in which Solomon's trying to make his position clear. So they start at, they've started there and they go on to page 79. So Ashcan at the bottom of the page says thanks, and then later, do you agree that it would be better to obtain a payment from the Sheikh with the case continuing against Amjad instead of no payment and a global drop hands for all parties? Going up, we agree, says Solomon. Let's see what we can get from them by close of business today, otherwise go drop hands for all parties. And then Mr. Candey saying, why rush to do a deal today? And Solomon comes back, we're open-minded. Let's hear what the other side have to propose before we make our choices. I'm sure you're a good negotiator. going up, Solomon saying, sorry if I disappointed you. May I instruct you that you try to reach a financial settlement. If not, if there's no offer on the table, that you try a drop hand on behalf of all parties, as we don't want to create enemies out of friends. And going up again, need to clarify without a drop hands, whether a drop hands without Amjad is acceptable. Yes, says Solomon at the top of the page, but it should not be our first call. And then we turn now a few pages ahead to to page 85. And at the bottom of this page is the offer from Sheikh Mohammed. Drop hands against you both without any requirement to attend trial. In fact, you would both agree not to give evidence. They will continue against Amjad, split any recovery they obtain 50-50. Want to cap the contribution to you at 1 million. Think they could agree to it being uncapped. Plainly a much better deal for you than a drop hand with no money. Please let me know your thoughts. And then about a third of the way down the page, Solomon comes back. Our instructions are as follows. An unconditional drop hands, because of course Sheikh Mohammed's offer is conditional on two fronts. One, it's conditional on the Bosheh's not giving evidence. And two, in practical terms, it's conditional upon Sheikh Mohammed receiving anything from Amjad, from Mr. Salpiti. So an unconditional drop hands, we've given our evidence and we stand by it, an uncapped share of damages. And then what we have is that instead of going back and negotiating further, the appellant comes back with further questions, particularly about giving evidence. And we've got a series of emails in which Solomon is trying to get his instructions across. If we turn to page 84, page 84, yeah. So we're going up about written things, about 2/3 of the way down. Our instructions, myself and my father, is for you to kindly liaise closely with the other defendants and conduct your negotiations with Baker Mackenzie with that in mind, as this will strengthen our position if we go into negotiations as a united front. If they accept drop hands for all, this is fine. If not, then you said our client is strong and can win. And then going further up, Solomon again, we want to go to court as we don't want to give up this fight. We don't think it's a good idea to have a drop hands with conditions. Our main concern is that we want a united negotiated front in which will make the position of everyone strong, but I need to understand our chances of success, which Mr. Candey gives towards the top of the page. And then we have, shall I reject their proposal? And someone says, please reject their offer in line with his earlier instructions. However, that's an unfinished email. And then turning to page 83 at the bottom. We really wish you to kindly offer as part of our instructions a drop hands if the claimants drop hands with all the other defendants. Myself and my dad believe our negotiations, if conducted collectively in full coordination with other defendants, will bring better results. Please confirm that you will now negotiate settlements on all fronts without their conditions, as they're starting to take this. And also ask for proper advice on success. There's no evidence of any further attempt by the appellant to negotiate on all fronts. Instead, later that day, Mr. Candey sends a fairly aggressive email and then says, please confirm that notwithstanding the position, he wishes to reject yesterday's offer and propose instead of drop hands. And in the email in the centre of the page, in my submission, it is notable that it says, we can settle this in terms that you stand to be paid £1 million, which you could then use to settle our fees. But instead you wish us to look after Amjad, notwithstanding allegations of negligence. Now, my lords, in the light of that contemporaneous correspondence, in my submission, the appellant does not have real prospect of successfully establishing breach of any term of good faith.
Sorry, no real prospect.
Of successfully establishing any breach of any implied term of good faith. And that is because, in my submission, the appellant's solicitor has no real prospect of successfully establishing that the Boshehs instructed the claimant to reject any payment to the Boshehs. Indeed, as we've seen, the instructions were frequently to try and go back and negotiate a financial settlement as a preferred option. And also, the appellant's solicitor has no real prospect of successfully establishing that the Boshehs' counteroffer was substantially less advantageous than Sheikh Mohammed's offer, given that on the appellant's own position, the Boshehs wouldn't receive any money under either, but under Sheikh Mohammed's offer, the Boshehs would agree not to give evidence in circumstances where a family friend was also a defendant and would be at risk of adverse findings being made against them in a judgment. And also in my submission, it's quite something to say that, as my learned friend began to do, that one has to look at the objective position when looking at interests, and one cannot take into account emotional interests, whether those be agreeing not to give evidence or risk of adverse findings, or the fact that a co-defendant, albeit separately represented, may want your assistance in relation to evidence and is a family friend. And in my submission, therefore, the judge was correct to grant the respondent's summary judgment in relation to that claim. Ground 4 is no longer pursued.
So that was just so that I'm clear. So she, I can't recall. Did she deal with that by way of reverse summary judgment or by strikeout?
It's at paragraph 88, taking the claimant's case at its highest, it has no real prospect of successfully establishing the implied terms.
And
Judgment should be given to the defendants.
which means that it's the cost term claim alone, and nothing that your submissions or Mr. Bompas's submissions this morning go to that remains.
Yes.
The
so
costs term
the
claim.
costs term claim remains. That is in this is Justice Ambrose's order.
Yeah.
That's the only claim that can go forward.
You said you were moving on to ground 4. I thought that had been.
I was merely saying that ground 4 is no longer pursued by the appellant. So we're moving on to ground 5. In the respondent's submission, the learned judge below was clearly correct to refuse permission to amend in circumstances where the appellant sought to rely on privileged material. But in any event, the appellant has no real prospect of success in respondent's submission in relation to its express misrepresentation amendment. And this was, of course, part of the amendment application, so the burden of proof would be on the appellant. And the starting point here in my submission is the statement in Valdemir and Holdings and Valderino, which is, I don't think I need to take you to it necessarily, it's in volume 2, tab 17, page 474, paragraph 132. It is essential in any case of fraud for the dishonest representation to be clearly identified. And there has been a significant lack in my submission of such clear identification in the incident case.
Yeah.
The proposed amended particulars of claim representations in paragraph 6A, is an oral representation to the claimant. There's one that the claim would not succeed as found in the hearing below. That the second defendant did not have access to and did not own the Yahoo account or the RBS account. And in the defendants, and that's said to be a representation by the Boshehs. In the appellant's skeleton argument at the hearing below, it was that Mr. Bosheh owned and controlled the RBS account, not Mr. Salfiti, and that Mr. Bosheh owned and controlled the Yahoo account, not Mr. Salfiti. In the judgment, the learned judge referred to alleged representations as pleaded, that Mr. Salfiti did not have access to or own the Yahoo account or the RBS account. And in the appellant's appeal skeleton argument, the alleged representation is that Mr. Bosheh was the owner and controller of the Yahoo account and the RBS account. In the proposed amended particulars claim, the representations were said to be made by Mr. Bosheh and Suleiman. At the hearing, it was said that they were made by Mr. Bosheh and Mr. Salfiti, and that the claimant was not alleging that Suleiman Bosheh had made any fraudulent misrepresentations. The appellant's appeal skeleton argument seeks to introduce a new representation that Sheikh Mohammed's claim that Salfiti was the true lender was false. That didn't appear as a representation in the proposed amended particulars of claim, or in the skeleton argument below, or in the grounds of appeal. And in my submission, I thought can and should ignore that. Now, the proposed claim was to the effect that the appellant solicitor was induced by the misrepresentations to enter into the retainer. Retainer was a defined term, so at paragraph 3 of the proposed amended particulars of claim, and this is behind tab 12, on page 148. Ignoring the bit in the initial bit in red, which is in relation to a claim that was abandoned below. The claimant acted on the basis of a conditional fee agreement, which was subsequently varied for the claim. First, on the 8th of February 2019, the damages-based agreement. There may have been two variations, one at a meeting and then another one to introduce Suleiman Bosheh. And second, on the 11th of January 2021, to a conditional fee agreement with retainer. Pursuant to the retainer, the claimant believed that it provided legal services to the Boshehs and representatives throughout the duration of the claim. And if you turn to paragraph 2, at the top of page 148, on or about the 20th of September 2018, the claimant agreed to act with the first defendant only, so not Mr. Salfiti. And then the inducement is at paragraph 7. The claimant entered into the retainer induced by and in reliance upon each of the representations set out. Now, the difficulty with that in my submission is that the retainer commenced on the 20th of September 2018, and if one turns to the evidence of Mr. Candey, which is...
He says the instructions were given later.
He says the instructions were given later. Yeah. And also the instructions were given by Bosheh later.
Yeah.
So the appellant has in my submission failed to identify any representations made before entering into retainer. And finally, in relation to the express misrepresentations, the judge correctly exercised her discretion in terms of the privilege, in terms of the real prospective success, although she didn't take that into account, and in terms of the fact that the judge had found that many of the complaints, most in fact of the complaints of abuse of process that the respondents had raised were made out of this part. Those are my submissions on ground 5. Ground 6 is no longer pursued.
Yeah. So that just leaves ground 7.
Ground 7, which in my respectful submission is entirely incomprehensible. It appears that my learned friend's position is that if he succeeds in relation to ground 1 on privilege, then it automatically follows the reasons that I struggle to understand that he should succeed on ground 7. Again, the starting point is that a plea of conspiracy is a serious charge engaging the requirement of clear pleading and convincing proof. And that's at a Lesko, which is in volume 3, tab 19, page 72, paragraph 371, and it's quoting citing the Court of Appeal in German. It's wholly unclear what the case is in my submission, but in any event, insofar as one can pick out of it a suggestion that there was an intention to injure, Mr. Candey's evidence is that it would have been reasonably foreseeable that their action would injure the claimant. And the test, that is not the test. The test is summarised in the Lesko behind, so I will have to take you to volume 3, tab 19. Page 727. Page 727. Paragraph 373, and this is just summarising the test for intention. Second sentence, if the intention to injure is not the predominant purpose, the defendant's intention must be to inflict damage as the means whereby to protect or promote his own economic interests. Foreseeability or probability of loss is not enough. At paragraph 166, Lord Nichols stressed that a defendant's foresight that his unlawful conduct may or will probably damage the claimant cannot be equated with intention for this purpose. My Lord, so on at least one point, that claim must fail on the evidence in my submission.
Yeah.
Otherwise, in my submission, the claim is incoherent, incomprehensible, and unless your lordships have any particular questions on the point, I don't propose to go into it in any detail. In relation to procured breach of contract, it said that this necessarily follows from the claimant's claim of deceit and unlawful means conspiracy. In the defendant's submission, it doesn't. The claimant hasn't set out what action the parties to sub-media rely on, and the defendant must know the case it has to answer. And there are at present no reasonable grounds pleaded for this claim.
Right, just hang on a minute. Right, we don't have any other questions for you. Thank you very much, Simon. Yes, Mr. Norton, anything in reply?
I'll try to be as brief as possible. I do have one or two observations. Goldman and Hesper, there was a passage that the court was shown in that case. It's worth bearing in mind that that case was a party-and-party taxation case. And the question was whether the judge could see documents which the other side weren't going to see. So that's how that particular point arose. And then, since there were two competing authorities before there had been a rule change, one of which seemed to think that it seemed to suggest that it was okay for the court to see the documents. The next point was a privacy point. my own friend made the suggestion that for example, a trustee seeking directions can come to the court and seek privacy. And an answer to Paragon may very well be that the way that a case of this nature should be brought is in private. We are where we are, as they say now, and for this particular case, it's going to be that the documents produced in court use of those confined to the present proceedings. But Paragon, what had happened was the proceedings were brought in open court by the client, and hence it was said that the publicity had been brought to the court, brought to the proceedings, which then stripped away the right of the claimant to claim privacy. A comment was made by my lord in the course of argument concerning the possibility that the material held by Candey is held by Candey as agent, and that might have some relevance to the question of the way in which it can be used as between Candey and the client. To which, of course, the answer is that some of the material, no doubt, is held in that way, but there are other matters which are not, so that what would ordinarily be regarded as confidential privilege is not just documents, but it'll be communications which may have been made orally and then reduced to an attendance note or something of the kind, which on traditional grounds would belong to the client, the solicitor, rather than the client. But that's a small point. I mean, the question is whether the communications can be used by the solicitor in the course of proceedings against the client for the purposes of making recovery, either for costs, for fees, or more widely, something arising out of the relationship. My own friend sought to, as it were, distinguish Barclay's case, at one point highlighting the fact that it concerned legal advice privilege rather than litigation privilege. Ablyazov, if I may suggest it, knocks that distinction on the head. But also, my own friend suggested that the context of that case was a section, I think, 423 Insolvency Act proceeding, which is labelled in the side note to the Insolvency Act, transactions in fraud of creditors, or transactions defrauding creditors. That's perfectly true, but actually dishonesty is not a required ingredient of such a cause of action. And thus, the court was perfectly alive to the point that there was something iniquitous about the conduct rather than dishonest or fraudulent. The Nationwide case was, we suggest, again, in line with the Barclays line, the Eustace case, in having a lower threshold than is required for dishonesty or fraud to bring into play the iniquity exception in the context of privilege. And as I think my own friend submitted, the question is not really one of an exception. It's that in the area where there's fraudulent activity or the iniquitous activity, there is no confidentiality and no privilege because of the iniquity. Yes, my own friend placed quite a lot of weight on the Derby case, which is true. The Derby case, a criminal case, set a very high threshold for privilege. It places privilege, one might almost say, in a paramount position. The right of the client, in that case, not to have the client's documents produced by compulsion to the magistrate, was held to override the right of possibly the defendant in the proceedings to defend himself to a murder charge. But it's worth keeping in mind that even in the passage, I think it's Lord Taylor, that the passage in the speech in the House of Lords that has the sort of purple prose. It's contemplating that the privilege allows the client to make a bare breast of matters to the lawyer to tell the truth. And this is in a traditional solicitor-client relationship where the client has to be able to engage the client's lawyer, saying the things that are uncomfortable for the client, and nonetheless expect them not to be disclosed. We're in a slightly different world since that case. We're in CFA world and in civil proceeding. And so the question actually comes down to the root point. Can a solicitor pursue the client using confidential material? Includes the client, no one else, the client using confidential material, whether it's for cost or I suggest going wider. The next point, and I want to be very brief on this one, is the Bates point, which my learned friend took the court to, going through the various headings set out by Mr. Justice Fraser in the paragraph 725 of his judgment. And it's absolutely correct that this is not a commercial contract in the present case of the kind that was being contemplated by Mr. Justice Fraser, where it's characterised as a commercial contract. The contract we have is one in which one has, I suppose one could say, consumers contracting with a lawyer. It's quite, in some ways, quite unique, quite distinct from the Bates case. But what I would suggest the Bates headings are not is a statute defining the what's required for there to be implicit in the contract good faith on the part.
Well, I think Mr. Justice Fraser is very quick to point that out.
Well, but not yes. So if I won't. I mean, one can sort of find ways of comparing and contrasting the present situation with the post office staff in Bates. But what we say is, and I think you've had my submission this morning, that it would be right that there is some obligation, some duty in the retainer owed by the client to the solicitor, some cooperation required, and then you have to see what springboard is for that. My learned friend developed argument on ground 5 and ground 7. And her attack here was quite directed to the pleadings, the pleaded case. The problem that I think I'd have to accept is that the pleaded case has not been well pleaded and the judge's criticisms of it were correct. However, we're in a bind. We can't put forward a better pleading because we then land ourselves in a pickle with the underlying case, whether or not we can deploy the material that's gone back and forth, as it were, behind the curtain, to develop our contentions. The one point that does need to be corrected, though, is the suggestion that my learned friend made that as it were, life started sometime in September 2018, and only a representation before that time, if pleaded, could have founded a case in deceit. Now, I would suggest that's wrong on two fronts. What actually one's looking at is the time when the second case, the settled proceedings get started, and the parties formed their second agreement, the damages-based agreement. And what was imparted to the solicitor before that time was going to be relevant to the making of that agreement. And that agreement was made in February, so the evidence is. And then it went on in time, so that a misrepresentation, a false statement made, just knowingly false, after even February 2019, with the expectation and the intention that solicitors would act on it in the course of the proceedings, and of course incur costs in going on with the proceedings on the basis of this, would I would suggest found a case in deceit. But all that depends on knowing what was told to the clients. One can assume, by the client, one can assume something was, because we have seen that there were pleadings. But what is again, it's behind that curtain. So I would suggest that, as I submitted in my first submissions, that grounds 5 and 7 really follow behind ground 1.
Yeah.
And if we fail on ground 1, then we fail on it all. But if we succeed on ground 1, then the proceeding should be allowed to go forward. Look at that. Sorry, forgive me. I've been... I have no further submissions.
We don't have any other questions for you, so thank you very much. Right, thank you all very much, and all those behind you. We will reserve our judgments because we are close to the end of term. I'm afraid I can't give you any indication as to when those judgments will be completed. They will be sent out in the usual way, that is in draft, that is to enable the parties to correct our typographical skills and our English grammar, but it is not an excuse to re-argue the case. The judgment will be only completed once the parties have returned the typos and the other matters, and the judgment is finalised. It is only the finalised judgment that matters, so the draft judgment that is sent out is a draft, and as I'm sure you both know, any circulation of the draft judgment to those other than those who are entitled to see it is a contempt of court, and the warning of that is front and centre on the front page of the judgment, and as you will both know, this has sadly arisen because of a number of breaches in recent months. So the draft is only to be seen by the lawyers effectively working on the case. I don't think there's anything else. Once we have completed the judgment with your assistant, we should also ask you to agree an order. If you can't agree the precise terms of the order, then any short submissions on the points of difference should be in writing, and we will decide those at or shortly thereafter, the time that we hand down judgment. There's no need for anybody to attend for the hand down, which these days is almost always electronic anyway. Thank you very much.